In this lecture, we're going to be covering chapters 19, 20, and 21. Chapter 19, Warranties, Product Liability, and Consumer Protection. A warranty is an assurance that the article sold will conform to a certain standard or operate in a certain manner. The seller is agreeing to make good on any loss or damages if the goods are not as represented. If you're following along in your e-text, 19-1, Express Warranties. An express warranty is a statement of guarantee by the seller. If the guarantee is part of the basis of the bargain, it is an express warranty. A promise with legal assurances that the product you purchase will perform as advertised. If it does not, you have legal recourse. 19.1a discusses a seller's opinion. A seller's opinion is not a warranty, and therefore the seller will have no liability. This is known as puffing, when the seller offers his opinion about the product being sold, such as, "This is the best on the market for the money." Another example of a seller's opinion would be, "Experts have estimated that one ought to be able to sell 1,000 units a month." The courts have found that this type of showmanship, this type of seller's opinion, is not a warranty, and therefore there won't be any legal recourse if the product doesn't perform according to the seller's opinion. 19.1b, defective goods. If defects are known or can be clearly identified before purchase, an express warranty may not cover them. In other words, if you as the buyer know that you're purchasing goods that are damaged or slightly defective in some way, then you are essentially waiving any warranty in regards to the defects that you knew about at the time that you purchased the particular good. 19-2, implied warranties. These are warranties imposed by law. They automatically arise when a sale has been made. For example, every seller implies that he or she owns the goods being sold and that he or she has the right to sell them. Full or limited warranties. A full warranty, the seller must remedy any defects without charge. There's no time limit, and the good must be replaced or the money must be refunded. A limited warranty is limited as to the time, such as it's a 1-year warranty. It limits damages, such as to repair this product or replace it, you have to send it back to the manufacturer, and the warranty will not cover shipping costs or incidental damages. And limited warranties will have exclusions, such as the warranty doesn't apply to commercial use of a consumer product. Warranty of title. Seller has good title and the right to sell. Warranty against encumbrances. This is a warranty that there are no liens or encumbrances, such as a title loan on a vehicle, on the particular good that's being sold. Warranty of conformity to description sample. So a sample is a portion of the mass. It's just one sample of whatever it is that you're going to buy in bulk. And so the warranty of conformity says that the sample that you get to try is the same as the rest of the products that you are going to purchase. They're going to conform to that sample. A model is a replica of a product. The goods must conform in kind and quality to the description of the sample or model. Warranty of fitness for a particular purpose. When the seller knows that the buyer intends to use the product for a particular purpose, and the buyer relies on the seller's judgment when making the purchase, such as, I want to buy a mountain bike for trail riding, and the seller instead sells you a 10-speed, knowing that you're relying on the seller's expertise to sell you the type of bike that you want. In that particular example, there would be a breach of that warranty of fitness for a particular purpose. A merchant is a seller who deals in a particular good. Merchants have particular knowledge or skills regarding the goods that they're selling. It's their occupation to sell a particular good. Warranty against infringement. Unless otherwise agreed, a merchant warrants goods will be delivered free from any claim of any third person by way of patent or trademark infringement. For example, Southern Miss was sued for a copyright infringement by the Iowa Hawkeyes over its eagle head logo, and it's eventually had to change that logo because it did in fact infringe on Iowa's logo. Warranty of merchantability of fitness for normal use. Sellers make an implied warranty of merchantability, that the goods are fit for the purpose for which they're being sold. If the goods cannot be sold, such as they're in poor condition, it triggers a breach of this warranty. Warranties in sales of particular goods, such as the sale of food or drink. When, let's say, a vendor at a sporting event is selling food and drink, there's an implied warranty that the food is fit for the purpose of consumption. Sale of an article with patent or trade name. The sale of a patented or trademarked article does not bar the existence of a warranty of fitness for a particular purpose. If the buyer specifically requests a patented or trademarked article, then no implied warranty of fitness applies. If the buyer relied on the seller's skill and judgment, even if the brand name products were used, an implied warranty of fitness does in fact exist. Sale of second-hand or used goods. No warranty arises to fitness of used property from a sale made by a casual seller. If made by a merchant seller, such a warranty exists. Leased goods. Many people and businesses lease expensive goods. States which have adopted Article 2A of the UCC treat leases the same as sales, including express and implied warranty provisions. Exclusion and surrender of warranties. Disclaimers. Statements such as there are no warranties that extend beyond the description on the face hereof excludes all implied warranties of fitness. Language such as sold as is or sold with all faults excludes all implied warranties of fitness. Examination by the buyer. If the buyer does not examine the goods thoroughly for defects prior to purchase, no implied warranty exists. Caveat emptor is Latin for let the buyer beware. It requires purchasers in ordinary sales to act on their own judgment, except when sellers have given express warranties. It applies when the buyer has full opportunity to make an examination of goods that would disclose the existence of any defect and the seller has not committed fraud. Product liability, privity of contract in breach of warranty. In the past, in common law, there could be no suit for breach of warranty unless privity of contract, in other words, a contract relationship, existed between the plaintiff and the defendant. Warranty protection. According to the Magnuson-Moss Warranty and Federal Trade Commission Improvement Act, the consumer must be informed of the warranty prior to the sale. The Act also requires no written warranty may waive the implied warranties of merchantability and fitness for a particular purpose during the term of the written warranty. The effect of repossessing or reprocessing by distributor. Frequently, a manufacturer will have the distributor or retailer make changes to the product. The manufacturer is not liable for that final product a consumer may purchase if the retailer does not complete the additional processing. 19-9 discusses identity of the parties, third persons. The UCC permits recovery for breach of warranty by the guest of a buyer. A conflict of authority exists as to whether an employee of the buyer may sue the seller or manufacturer for breach of a warranty. Manufacturer of component parts. The harm caused may result from a specific component in the final product. Because the manufacturer of the total article was the buyer from the component part manufacturer, the component part manufacturer is not liable. Nature and cause of harm. The law is more concerned with personal injury than economic injury. The plaintiff must only show a sale and warranty existed. The goods did not conform to the warranty and an injury resulted. Product safety. Products with safety standards include toys, television sets, insecticides, pharmaceutical drugs, and many others. Consumer Product Safety Commission has broad power over safety standards for many products. It can also halt distribution or ban the product entirely. Truth in advertising. The Federal Trade Commission is responsible with preventing deceptive acts or practices in or affecting commerce. The FTC has limited advertisements to make statements which can only be validated. Product uniformity. Consumers are given the ability to make intelligent choices when comparing competing products. Unit pricing, price stated per unit of measurement, is an example. Usury laws. Usury laws are laws that fix the maximum rate of interest which may be charged on loans. They recognize the borrower is frequently in a weak position and therefore unable to bargain effectively for the best possible interest rate. Truth in Lending Act requires lenders to make certain written disclosures to borrowers. These include finance charges, the annual percentage rate, the number, amount, and due dates of all payments, including any balloon payments, payments which are more than twice the normal installment payments. Statutes prohibiting unconscionable contracts. If a contract is so harsh or the price so unreasonably high as to shock the conscience of the community, Section 2-302 of the UCC gives courts with authority refusal to enforce it. Fair Credit Reporting. The Fair Credit Reporting Act requires creditors to notify a potential recipient of credit whenever any adverse action or denial of credit was based on a credit report. An incorrect credit report must be corrected by the credit agency. State consumer protection agencies have injunctive powers, which is a power to issue a cease and desist order. Some states have enacted laws giving state officials the authority to compel fairness in advertising, sales presentations, and other consumer transactions. Let's do the chapter review questions for Chapter 19. Question 1, what is a warranty and to what does a seller agree by making one? A warranty is an assurance that the article sold will conform to a certain standard or will operate in a certain manner. By making a warranty, a seller agrees to make good any loss or damages that the purchaser may suffer if the goods are not as represented. Question 2, how does a seller create an express warranty? Any affirmation of fact or promise made by the seller to the buyer that relates to the goods and becomes part of the basis of the bargain creates an express warranty. Question 3, what are the warranties made by all sellers? Briefly explain each of them. All sellers make a warranty of title, that they have good titles and make rightful transfers, a warranty against encumbrances, that the goods shall be delivered free from any security interest or any other lien or encumbrance of which the buyer at the time of making the sales contract had no knowledge, a warranty of conformity to description, sample, or model, that the goods shall conform in the kind and quality to the description, sample, or model and warranty of fitness for a particular purpose, when the seller has reason to know at the time of contracting that the buyer intends to use the goods for a particular or unusual purpose. The goods will be fit for that purpose. Question 4, do all merchant sellers make an implied warranty against infringement? When a buyer supplies the seller with exact specifications for the preparation of manufacture of goods, a merchant seller makes no implied warranty against infringement. Question 5, what warranty does a merchant who sells food or drink make? A merchant who sells food or drink makes an implied warranty that the food or drink is fit for its ordinary purpose of human consumption. Question 6, does the sale of a patented or trademarked article bar the existence of a warranty of fitness for a particular purpose or of merchantability? The sale of a patent or trade named article does not bar the existence of a warranty of fitness for a particular purpose or of merchantability when the buyer relied on the seller's skill and judgment when making the purchase. Question 7. What is the impact of Article 2A on leased personal property? Article 2A, which applies to personal property leasing, treats lease transactions similarly to the way Article 2 treats sales, which includes express and implied warranty provisions. However, a warranty of possession without interference replaces the warranty of title. Question 8. How many warranties must be executed or surrendered? How may warranties be executed or surrendered? Warranties may be executed or surrendered by agreement of the parties as long as such an agreement is not unconscionable. Question 9. When does the rule of caveat emptor apply? The rule of caveat emptor applies when the buyer has full opportunity to make an examination of the goods that would disclose the existence of any defect and the seller has not committed fraud. Question 10. Does the rule requiring privity of contract keep everyone except the purchaser of goods from suing the seller or manufacturer for a breach of warranty? The rule requiring privity of contract no longer keeps anyone other than the buyer from suing the seller or manufacturer for breach of warranty. The UCC expressly allows members of the buyer's family, household, and guests to sue for personal injury. Employees are also frequently allowed to sue for a breach of warranty. Even a prisoner has been allowed to sue on this basis. Question 11. According to the Magnuson-Moss Warranty and Federal Trade Commission Improvement Act, what must be included in a warranty? According to the Magnuson-Moss Warranty and Federal Trade Commission Improvement Act, clear disclosure of all warranty provisions and a statement of the legal remedies of the consumer, including informal dispute settlement under the warranty, must be a part of the warranty. Question 12. For what may individuals whose rights under the Fair Credit Reporting Act have been violated sue? Individuals whose rights under the Fair Credit Reporting Act have been violated may sue for and recover ordinary damages if the harm resulted from negligent non-compliance. If the injury resulted from willful non-compliance, the aggrieved party may seek punitive damages. Chapter 20, Nature of Negotiable Instruments. The act of transferring ownership of a negotiable instrument is referred to as negotiation. The owner negotiates it by signing the back of it and delivering it to another party. The signature of the owner made on the back of a negotiable instrument before delivery is called an endorsement. Holders in due course are individuals who acquire the rights superior to that of the original owner. Two types of negotiable instruments are order paper and bearer paper. Order paper is commercial paper made payable to the order of a named person. Bearer paper is commercial paper made payable to whoever has possession of it. Classification of commercial paper: drafts or bill of exchange, This is a written order by one person directing another to pay a sum of money to a third person. A common example would be writing a check drawn on your bank account. Promissory notes are unconditional written promises to pay a sum of money to another. Parties to negotiable instruments. Payee agrees to receive payment in the future. The party to whom the instrument is made payable is the party that receives the money. The drawer agrees to pay the payee. This is the person who signs the draft, the person who owes the money and is going to pay that money. And the drawee would be the bank. The person who ordered to pay a draft orders the bank or any other institution where money is kept until it is paid out. Acceptor, such as accepted by Jane Doe, is the person who agrees to pay a draft. A maker is a person who executes a promissory note and contracts to pay the amount due on the note. And the bearer is payable to whomever is in possession of the negotiable instrument. A holder is any person in possession of an instrument that has been delivered to the person. It can be either order or bearer paper. A holder in due course is a holder who takes a negotiable instrument in good faith and for value. An endorser is a payee or holder who signs the back of an instrument. The endorsee is the person who becomes the holder when the check is endorsed over to that person. Negotiation and assignment. Negotiation of instruments may be transferred through negotiation or assignment. When an instrument is transferred by assignment, the assignee receives only the rights of the assignor and no more. If one of the original parties to the instrument has a defense that is valid against the assignor, it is also valid against the assignee. When a party receives an instrument through negotiation, that party receives rights superior to the original holder. Defenses that may be valid against the original holder may not be valid against a holder who has received an instrument by negotiation. Credit and collection. Credit and collection are instruments of negotiation. For example, if A sells B merchandise on 60 days credit, the buyer may at the time of the sale execute a negotiable note or draft due in 60 days in payment of the merchandise. This note or draft then is an instrument of credit. Electronic fund transfers. Fund transfer initiated electronically, telephonically, or by computer. Electronic Fund Transfer Act regulates electronic fund transfers. The EFTA requires notification for electronic fund transfers and how it is affecting a consumer's account, such as what liability could be imposed for unauthorized EFTs, what type of EFT the consumer may make, and charges for making an EFT. Check truncation is shortening a check's trip from the payee to the drawer. Pre-authorized debits and credits. This is an automatic deduction of bill payment from a checking account. automated teller machines. This is an EFT terminal that performs routine bank services. Point of sale system. This is an EFT that's begun at a retail store when the consumers or customers pay for goods or services. The chapter review questions. Question 1, what is a negotiable instrument? A negotiable instrument is a writing drawn in a special form that can be transferred from person to person as a substitute for money or as an instrument of credit. Question 2, since all the states have adopted the Uniform Commercial Code, is the law the same in every state? While all the states have adopted the UCC, they have not necessarily adopted the law exactly as written. They frequently make minor changes that do not significantly affect the impact of the law. Question 3, how does the owner negotiate a negotiable instrument? The owner negotiates a negotiable instrument by signing the back of it, so endorsing it, and delivering it to another party. Question 4, to whom may order paper and bearer paper be paid? Order paper may be paid only to the person to whom it is made payable on its face, or the person to whom it has been properly endorsed, whereas bearer paper may be paid to any person in possession of the paper. Question 5, what does it mean for a promissory note to be a demand instrument? If a promissory note is a demand instrument, the holder may demand payment or sue for payment at any time and for any reason. Question 6, who is a holder? A holder is any person who possesses an instrument if it has been delivered to the person and it is either bearer paper or it is payable to that person as the payee or by endorsement. Question 7, are the rights given to parties subsequent to the original payee the same whether the instrument is transferred by assignment or negotiation? The rights given to parties subsequent to the original payee are not the same when an instrument is transferred by assignment or negotiation. An assignee receives only the rights of the assignor and no more. However, a party to whom an instrument is transferred by negotiation may obtain rights that are superior to the rights of the original holder. Question 8, what is the limit of a customer's liability for an unauthorized EFT, and what is the customer's responsibility in order to so limit the liability? A customer's liability for an unauthorized EFT can be limited to $50 if the customer gives the bank very prompt notice of circumstances that led to the belief that an unauthorized EFT has been made. Question 9, what does it mean to a customer when a bank uses a system of check truncation? When a bank uses a system of check truncation, it means that the customer does not receive the actual canceled checks. The customer receives a statement with a list of check numbers and dollar amounts on the checks, either by mail or electronically. Question 10, what are the benefits of a pre-authorized credit to both the payor and payee? A pre-authorized credit benefits the payor, who does not have to issue and mail a check, and it benefits the payee, who does not have to bother depositing a check and normally has access to the funds soon. Chapter 21, Essentials of Negotiability. 21-1 lists the requirements. Assigned writing. The instrument must be in writing and signed by the party executing it. Order or promise to pay. The instrument must contain either an order to pay or a promise to pay. Unconditional. The order or the promise must be unconditional. Fixed amount of money. The instrument must provide for the payment of a fixed amount of money. Payable on demand or definite time. The instrument must be payable either on demand or at a fixed definite time. Payable to order or bearer. The instrument must be payable to the order of a payee or to a bearer. Payee and drawee designated with reasonable certainty. The payee, unless the instrument is payable to the bearer, and the drawee must be designated with reasonable certainty. Issue and delivery. Issue, the drawer or maker mails it or hands it over to the payee. Delivery, the intentional transfer of possession and control of the instrument. To negotiate order paper, it must both be endorsed and delivered. Delivery of an incomplete instrument. The maker or drawer is liable if the blanks are filled in according to instruction on a partially filled or signed negotiable instrument. If the holder fills in the blanks contrary to authority, the maker or drawer is liable to the original payee. Date and place. The instrument need not be dated. The negotiability of the instrument is not affected by the fact that it is undated, antedated, or post-dated. The omission of a date may cause considerable inconvenience, but the date is not essential. The holder may fill in the correct date if the space for the date is left blank. If an instrument is due 30 days after date and the date is omitted, the instrument is payable 30 days after it was issued or delivered. In the case of a dispute, the date of issuance may be provided as proof. The name of the place where the instrument was drawn or where it is payable need not be specified. For contracts in general, the law where the contract is made or where it is to be performed governs one's rights. This rule makes it advisable for a negotiable instrument to stipulate the place where it is drawn and where it is payable, but neither is essential for negotiable instruments. All right, Chapter 21, Chapter Review Questions. Question 1, in what form does the law require a negotiable writing to be? The law does not require that a writing be in any particular form in order to be negotiable. It may be written with pen and ink or with pencil. It may be typed or printed, or it may be partly printed and partly typed or even handwritten. Question 2, in what way may the signature on a negotiable instrument be placed on the instrument, and what may it consist of? The signature on a negotiable instrument may be handwritten, typed, printed, or stamped, and it may consist of a name, a symbol, a mark, or a trade name. Question 3. Must the word promise appear in an instrument in order for it to be negotiable? The word promise need not appear in an instrument in order for it to be negotiable, but the language used must show that a promise is intended. Question 4. What does it mean for the order or promise in an instrument to be unconditional? An order or promise in an instrument is unconditional if it is not contingent upon any other act or event. Question 5. Does a reference in an instrument to a separate agreement make the order or promise conditional? A reference in an instrument to a separate agreement does not make the promise or order conditional unless the promise or order states it is subject to or governed by another agreement. Question 6. In order to be negotiable, must an instrument be payable in American money? An instrument need not be payable in American money in order to be negotiable. However, it must be payable in some national medium of exchange that is legal tender at the place payment is to be made. Question 7. Give 2 examples of provisions in an instrument that do not destroy negotiability even though they would change the amount to be paid. Provisions in an instrument that do not destroy negotiability even though they would change the amount to be paid include a provision for the payment of interest, exchange charges, cost of collection, 10% attorney's fee if placed in the hands of an attorney for collection, and installment payments. Question 8. What is the result if the amount in words on an instrument does not agree with the amount in figures? If the amount in words in an instrument disagrees with the amount in figures, the negotiability of the instrument is not destroyed and the amount in words prevails. Question 9. Give 2 examples of wording on a negotiable instrument that makes it a bearer instrument. Wording on a negotiable instrument that makes it a bearer instrument includes pay to bearer, pay to John Doe or bearer, pay to the order of cash, and pay to the order of bearer. Question 10. How does failure to date or specify the place where an instrument is payable affect the negotiability of an instrument? The failure to date or specify the place where an instrument is payable does not affect the negotiability of an instrument. The holder may fill in the correct date. If the instrument is due a set number of days after date, the instrument is payable the set number of days after it was issued or delivered. It is advisable for a negotiable instrument to stipulate the place where it is payable, but it is not essential for its negotiability.